You do respect authority. You're not respecting my authority.
You're not respecting me, okay?
Well,
respect goes both ways. You're just a woman with a robe on. You're a woman, human being, just like I am, okay? All that criminal he's spitting out his mouth, he's a rogue too.
Do you really think it's appropriate to cuss here in court?
Do you think it's appropriate to sentence me under this racial program you got going here you call justice?
To keep and bear arms in order to shoot our own politicians. We have the right to keep and bear arms to shoot the police, to shoot your local government officials, your state officials, your president, your congressmen, your senators.
Yeah.
What did you mean by that?
I'm simply saying, one of the ways you prevent the misconstruction or abuse of the powers of the Constitution is by letting the people in Washington understand that you are armed.
All right, Noble Amir KCL. You complained about discovery. I think I've addressed that. I'm giving you the copies of the indictments, and you said you've never been interviewed. I am sure that Mr. Kiesler can give you now a date for you to be interviewed.
Objection, ma'am. I do not require the Office of Public Defense or any attorney at law.
Well, you told me that you were complaining that you hadn't been interviewed.
No, what I stated was, if he was representation on this case, he has not provided assistance. If he was representation for this case, the assistance is ineffective.
Well, my understanding is that Judge Smith has required Mr. Kiesler to represent you.
Objection. I've addressed this matter with Judge Smith. Judge Smith does not have jurisdiction and could not prove jurisdiction. Therefore, Judge Smith does not have the authority to make any decisions for me. And neither do you.
That's the person you're looking for. Please, sir, that is the person you're I'm trying to remedy things. Touch me and you will be tried. I'm a peace officer. You want to dishonor a court official?
The defendant's on the bailiff's desk.
Sir, are you here on behalf of Mr. Thompson? I said I was the administrator for that account.
Are you here as agent for him?
Could you guys please back up? Thanks.
Are you here as agent for him?
Not as agent, as administrator, much like you are administrator of this court.
Filburn might say that we can get away with in court.
Well, I think you have to make your own decision about constitutionality. In normal times, you follow what the Supreme Court law has said, but we don't strike down any of your laws. People sometimes go, the Supreme Court struck. We never strike down your laws, gentlemen. We just ignore them.
The issue that is most urgent at the moment is changing the world monetary system, the banking system. And this is a long story, and I know you don't want to spend a lot of time on it, but it is critically important. The banking system that we have is, to put it bluntly, legalized fraud.
What should be the proper relationship between a chairman of the Fed and a president of the United States?
Well, first of all, the Federal Reserve is an independent agency, and that means basically that there is no other agency of government which can overrule actions that we take. So long as that is in place and there is no evidence that the administration or the Congress or anybody else is requesting that we do things other than what we think is the appropriate thing, then what the relationships are don't frankly matter.
The banks aren't owed any of this money at all. They're owed zero, and so it's irrelevant to them. And what they do is keep increasing the amount they claim is owed in the hope that the borrower will keep sending them more and more money, become more and more frightened and intimidated, and that's what they keep doing. They never send her an accounting because they can't. It's impossible. There is no accounting. They're making it all up.
Mr. Speaker. There being no further discussion, the clerk will take the roll on the bill. It's 93 pages long, and nobody in this body has gotten a copy of it. They just adopted an amendment of unknown page length that we have not received. We have no idea what's in this bill.
What's up, fam? It's your girl Ike here, and I just wanted to do a quick video on, because I know some things that I don't think you guys know. And I want to share it with you because my level of outrage and frustration is at an all-time high. I don't even want to fucking be in this country no more. You understand what I'm saying? I just want to fucking leave. But I need to share this with you. Y'all know I'm a lawyer, I'm a former prosecutor, and I'm currently a defense attorney. I was a prosecutor in Manhattan, New York City. So let me explain to you, because we are getting a lot of feedback about these grand juries that are not indicting these police officers, and you need to understand something. The first thing you need to understand is that a grand jury presentation is an ex parte proceeding. What does that mean, Ike? Don't talk that lawyer shit. Okay, ex parte means one-sided. That means that there's only one side being presented in the grand jury. There is nothing to controvert or contradict what the prosecutor is putting in the grand jury, unless a defendant chooses to exercise his right to testify in the grand jury. And even then, the defendant is allowed to come in with counsel, but you as an attorney, me as an attorney, when I escort clients into the grand jury, I am not even allowed to fucking speak. Do you hear me? I'm not allowed to say shit. If I want to confer with my client because he might not be sure how to answer a question, we got to step outside and come back in. The grand jury, the entire presentation is controlled, is orchestrated by the prosecutor. The evidence that goes in, the witnesses that go in, how the evidence is presented, the spin. Prosecutors control the grand jury. There's no judicial oversight. Now, that's not till after you got an indictment. There's no judicial oversight about how the case is going to be presented, what witnesses are going to be presented, what charges are going to be presented. All of that is at the exclusive discretion of the prosecutor. Exclusive. If a prosecutor wants to get an indictment, bet your ass they will get it. They will get it, because that saying, it doesn't take anything to indict a ham sandwich, is fucking true. It doesn't take anything, and I'm a former prosecutor. 5 years, I indicted motherfuckers for 5 whole years. Okay? And I'm telling you, it don't take shit to do it.
The trials and tribulations of many people accused of criminal offenses are a direct result of not understanding the nature and cause of the accusation. The end result of this lack of knowledge and understanding is that the United States and the states have the largest prison population in the world and execute the most people. Lives and families are destroyed. Family farms are stolen by unscrupulous judges and attorneys. Hard-working folks who have done no wrong have lost their homes and savings and have been reduced to a state of poverty by an encounter with the American system of injustice. The horror stories are limitless. This author believes that this lack of understanding is the result of the dumbing down of America, a part of a scheme devised and orchestrated by foreign and domestic enemies of the people of the United States of America, not the least of which are the American Bar Association and the various state bar associations which sprang from England. These bar associations have concocted a Luciferian scheme, bringing the maritime jurisdiction onto the land, and the scheme undoubtedly includes every member of every bar association up to the dishonorable justices of the Supreme Court. These foreign and domestic enemies of the people of the United States of America are believed by many, including this author, to have schemed for years, at least since the founding of our nation, to establish a total takeover of not only our country, but the entire planet, and to enslave the people in their domestic quest to establish a one-world government or New World Order, created out of the chaos of the destruction of liberty and to be founded upon the ruins of the principles on which our once great nation was established, and with the slave labor supplied by once free, self-sufficient, and proud people. Yes, Virginia, there is a conspiracy. There is a conspiracy by attorneys to steal everything that you have and to make you a slave. The members of the bar bestowed honors, privileges, and immunities upon themselves in direct violation of the very constitutions that they have sworn an oath to uphold so they can steal with impunity. They have defecated on the principles of law and justice. This author has personally witnessed them laugh about their license to steal when referring to their membership in the bar. Lawyers have infiltrated and taking control of the legislatures so that they can enact laws for their own unjust enrichment. For the most part, they occupy or control the offices of the executive branches of the governments of the several states so they can sign the legislative enactments into law. They absolutely control the judicial branch so they can adjudicate and enforce the laws and divide the spoils among themselves. They control the banks so they can launder their ill-gotten gains. These zealous advocates of injustice will strip you of everything of value you have if they are given the least opportunity. If you hire one to help you out of a scrap with the law, for the most part, you'll end up in prison while your lawyer is sipping margaritas on the beach in Cancun, paid for with your money. Your ex-wife might even be with him. Only if you have as much money as T. Cullen Davis or O.J. Simpson once did, might you be able to buy yourself some justice. The justice these two colorful characters bought for themselves cost them their fortunes, but they evaded imprisonment and possible execution for a price paid in money. Most people don't have the financial resources with which to bribe the members of the bar, so they languish in prison while the lawyers take what little property they had, plus a bonus from the state for their services. When you go into a court accused of a crime and are inclined to hire a lawyer or accept a court-appointed lawyer to help you out, remember that the lawyer is being paid by the state and is licensed by the state. The judge is licensed and paid by the state. The jury is licensed and paid by the state. They at least have driver's license, don't they? The prosecutor is licensed and paid by the state. If the judge orders a psychological evaluation to determine if you are competent to stand trial, the psychobabblist is also licensed and paid by the state. The cop that accused you and will testify against you is licensed and paid by the state. If you're tried and sentenced to death, the cleric who comes to pray for your miserable soul before the execution is licensed and paid by the state. The guy who sticks the needle in your arm for the euthanasia is licensed and paid by the state. After they inject you with poison, the doctor that pronounces you dead is licensed and paid by the state. Could there be a hint of conflict of interest here? If the reader has ever had any experience with the modern criminal injustice system, the term contempt of court has taken on a whole new meaning for him. The lawyers fill the prisons with people who have injured no one but are convicted of statutory crimes of a maritime jurisdiction. Prisons are filled with people whose only crime was to be in possession of a substance that they, the lawyers, have declared to be illegal. Good parents are separated from their children for attempting to discipline them or because of a divorce. Fathers are in prison because they cannot pay the court-ordered child support. It is blatantly imprisonment for debt. People are in prison for exercising their presumed right to keep and bear arms. People are routinely thrown in jail for non-jailable trafficking offenses, and the Supreme Court in Atwater versus City of Lago Vista, number 99-1408, April 24, 2001, has said it's okay. People are jailed every day for such heinous offenses as not wearing a seatbelt or not paying a motor vehicle registration fee. America, the land of the slave and the home of the free, has more people in prison or more people on death row than any other country in the world, and new prisons are being built every day. And in order to keep these new prisons filled beyond capacity, the various lawyer-controlled legislatures are busy enacting more and more new statutory maritime crimes.
Mr. Speaker. There being no further discussion, the clerk will take the roll on the bill.
Mr. Speaker!
It's 93 pages long and nobody in this body has gotten a copy of it. They just adopted an amendment of unknown page length that we have not received. We have no idea what's in this bill.
Woe be unto you if you don't pay a tax that is presumed to be due. If you don't pay up, the zealous advocates of injustice will drag you into their secret maritime jurisdiction on the presumption of a tax debt and steal your bank account, your car, your home, and anything else they can find. You may even go to prison.
So why'd you get locked away?
Tax evasion. If you resist too much or know too much, they will send their minions, the police, to assassinate you in broad daylight with impunity. The lawyers protect their obedient minions. These police agencies, whose motto is to protect and serve, get away with murder on a routine basis. Yes, they do protect and serve their masters, the lawyers, very well. This is why this essay must be spread far and wide as quickly as possible. The word must get out. The attorneys will stop at nothing to keep the scheme of their maritime jurisdiction secret. One advantage that the people have is that the rats are not yet totally in control of the internet. Please use it. If you have a web page, please post this article. Another advantage that the people have is numbers. There are more of us than there are of them. The greatest advantage that the people have is the truth. Lawyers fear it. They go to extraordinary lengths to suppress it. If you want to know what fear smells like, find a judge after you read this article and explain what you're about to learn from the succeeding pages. Mail copies of this article to every lawyer, judge, legislature, and sheriff you can, if you know of any who can read. Let the pungent odor of fear waft across the land. They know that once the truth escapes, it cannot be held back, and once again covered with darkness, at least not for several generations. When they are exposed, they will be powerless and vulnerable. People eventually recognize the truth. The truth is light, and the darkness flees from the light. The American people still have a sense of justice, and the lawyers especially fear justice. How have they gotten away with the fraud for so long and managed to keep secret the maritime jurisdiction has come onto the land? The answer is because the lawyers also control the fourth estate, the institutions of religion and learning. The news media aids and abets the esquires by suppressing the truth and perpetrating lies. It is a form of Orwellian mass mind control. The people are constantly fed a stream of propaganda through the network news, the newspapers, the public schools, colleges and universities, all lawyer-controlled, and most especially the incorporated 501(c)(3) churches. Like all other corporations, these churches are controlled by lawyers. The corporations that the people work for aid and abet the lawyers by perpetrating the false truths in their corporate policies. The subliminal messages transmitted are the lies that America is a free country, slavery is abolished, America is the great land of opportunity, there's separation of church and state, and good Americans, and especially good Christians, should submit to the government. It is the patriotic Christian thing to do. These themes never cease. They are constantly bombarded and ingrained into the psyche of the people. Hitler recognized in his work Mein Kampf that if you told a lie and repeated it and reinforced it often enough, the people would begin to accept the lie as a truth. The bigger and more outrageous the lie, the better. After a period of time, when the lie is sufficiently programmed into the psyche of the national consciousness and is accepted as truth, the human mind does a remarkable thing. If the truth is then presented, it will be rejected as a lie. The psychobabblists have recognized this phenomena and termed it cognitive dissonance.
The most insidious threat to our basic freedoms, such as freedom of mind and freedom of speech, is a little-known phenomenon known as mind control. Mind control is the shaping of a person's attitudes, beliefs, and personality without the person's knowledge or consent. The only way to protect yourself from mind control is to understand how it functions. In this video, I will try to explain how governments and many other institutions and companies use mind control on you. The consciousness mind is your awareness at the present moment. You are aware of something on the outside as well as some specific mental functions happening on the inside. For example, you are aware of your breathing or the chair that you are sitting on. The unconscious mind consists of the primitive instinctual wishes as well as the information that we cannot access. What the conscious mind believes, the subconscious mind acts on. It works like programming a computer. You put in information and the computer will act on it. If you put in wrong information, the computer will still act on it. If a person believes something that is not true, the subconscious mind acts on it. How do we learn? What if I were to tell you that it's absolutely impossible for me to teach you anything? This has been scientifically proven many times. Everything you have ever learned, you taught yourself. People have shown you things, people have given you information, but it was your application of that information whereby then you taught yourself. Who taught you how to walk, eat, work? Think about it. A teacher told you how to do 2 plus 2, but it was only when you understood it yourself that you learned it. We have grown up with the idea that we sit in front of someone and listen because they are the teacher. Who is in control of your learning in this environment? And if you don't expose yourself to this system, can you be smart? Can you learn things? During our childhood, we programmed ourselves with memories and experiences that formed who we are today. I'm sure that you can understand that the school system plays a major role in how we think. And who controls the school system and makes sure every child gets exposed to it? Right, it's your government. Cognitive dissonance makes the mind automatically reject information that is not in line with previously accepted thoughts and beliefs. Many of the things that people believe are never questioned, especially if the information comes from a reliable source. People can be led to believe something that is not true if the information is carefully timed and presented by an accepted and respected authority. The purpose of propaganda is to direct public attention to certain facts. The principles of propaganda are the same principles of mind control, hypnotic suggestion, mental programming, distraction, and repetition. Distraction focuses the attention of the conscious mind on one or more of the 5 senses in order to stop conscious thinking. This induces a state of mind that is similar to daydreaming. Think about watching television, losing all sense of time and place, staring at a screen. When you stop conscious thinking and your mind goes blank, this is the hypnotic state of mind. It's something that occurs naturally, but can also be induced by clever manipulation. Think of the times you have seen flashing words on TV. These are a distraction for your eyes to lock onto in order to induce hypnosis. Any repeating light or sound pattern can lead you into a hypnotic state. A television screen appears static but actually flickers. The flicker rates can bring you into a hypnotic state of mind. A hypnotist repeats the same things with the same intonation to induce this state of mind in his subject. A hypnotist repeats the same things with the same intonation to induce this state of mind in his subject. A hypnotist repeats the same things with the same intonation to induce this state of mind in his subject. It is in this state of mind that someone is the most receptive to mental programming. Whether or not the subject accepts the information depends on 2 things: trust in the source of the information and repetition. Trust in the source of the information induces acceptance of the information as true, even if it is not understood. Repetition embeds the information into the subconscious so that when the subject gets the same information presented at a later time, it will be seen as true. Is it possible to program an entire population to respond to certain words in a certain way? The result of such programming would be a population that is highly suggestible. A newsreader uses the same kind of speech as a hypnotist. The eye contact made with the viewer is also used by the hypnotist. With selective use of different camera angles and video cuts, it's simple to distort the meaning of what someone says. For example, adding in a picture or an emotional expression. We are being bombarded by news articles about terrorism, full of horrible pictures and stories. Think about the word terrorism. How does it make you feel? If you trust the media, then every time they repeat this word, it will grow this feeling in your unconscious mind. You might not believe it the first time, but because they keep repeating it, eventually you see it as an absolute truth. The power of music is well understood. Music affects your emotions, mind and body. Sound causes changes in breathing, body chemistry, blood pressure and digestion. Fast music will speed up the nervous system, while slow music will slow it down. Even sounds that cannot be heard affect you. Very low frequencies can cause headaches, dizziness and fatigue. Repeating sound patterns can bring someone into a hypnotic state of mind and make them more suggestible. Reverse speech is sometimes used in music so that when you play it backwards, you get another message. The subconscious can decode and read these messages. Repetition of the message constitutes mental programming. In time, the effects of this kind of programming will appear.
Another method very successfully used by the lawyers to keep their secret under the cover of darkness is the age-old strategy of sending their minions to infiltrate, divide, and conquer any organization of people banding together to resist the present tyranny of the injustice system. The authors have personally witnessed the effectiveness of this strategy. The minions of the Esquire sent to infiltrate patriotic organizations are intelligent, skillful, and highly trained in the arts of deception and betrayal. They are people of likable personalities who are able to gain trust, induce people into offending some maritime penal regulation, and set them up for prison. The most active or successful patriots are the ones on the top of the list to be targeted. They must be beaten into submission or neutralized, sometimes with extreme prejudice. Witness the fate of Gordon Call.
Warm greetings to one and all. Welcome to part one of American Heroes, the Montana Freemen. Today, very few people know much about the Montana Freemen, and for those who may have heard something about them, they only know the story as it has been filtered by the establishment media. The official story, articles which parrot the same thing, populate the internet. Most people only know what they've been told. Do your own internet research, and what you're going to see, you're going to find headlines and articles using terms like armed and dangerous, white supremacists, militia, domestic terrorists. There have been books written about the Montana Freemen. You'll also find several attempts to tell their story via videos from third parties who have studied them. But today, you're going to hear the story as told directly from Dan Peterson, who is considered one of the leaders of the group, working right alongside Leroy Schweitzer. Let's start with the Gordon Call story. Call was a poor farmer in South Dakota. He had no money to speak of, didn't even make enough to meet the threshold of being required to file. He was poor. He didn't file for many years, and he was never bothered by anyone. He wasn't required to file. He didn't make enough money. One day, after not filing for about 9 years, because he wasn't required to, he went on a radio show, and he stirred up a hornet's nest. The radio station started getting more calls than they ever had from people saying they agreed with Call. He's right. They weren't going to file anymore either. And these calls kept coming and coming and coming. He really stirred it up, and that did it. He was now a target. The feds went after him. Long story short, they put him in prison for a time. He did his time, and he got out and went back to his life. End of story, right? No. The feds weren't satisfied. They summoned him again to court for another attack, more harassment, more intimidation. And he basically told them to take a hike. He ignored the summons. Didn't show up to court. That was his crime. One thing led to another in a story which reads like a very dark and gruesome horror story from Stalin's communist Russia. After being successful in evading intensive tracking and surveillance, he was snitched on and the feds caught up with him. Now, did they arrest him, put him back in jail again? Would be logical, right? No, they didn't do that. This is what happened. A Delta Force team flew out special in a private jet from Washington, D.C. with orders to kill him. Now, they had plenty of opportunities to take him peacefully when he was in town, moving around, in other places. But no, they waited until he was in a remote rural area in the evening hours, and finding him inside a house, they removed the woman who was in the house with him, and they laid down a horrific barrage of firepower intended to kill him just flat out. Now, the house was well constructed, made primarily of concrete. He survived. They went in the house, they found him alive inside. They tortured him, knocked his teeth in, took the butts of rifles and smashed his face in. He had broken bones and bruises everywhere. They then, listen to this, they took an axe, they hacked off his left hand. Screaming in pain and bleeding profusely, that wasn't enough. They then hacked off his right hand. And they proceeded to hack off both of his feet. That wasn't enough. They then put a bullet in his head from close range. A local deputy sheriff was given the honor of removing the bullet from Gordon Call's head as a souvenir. To cover their tracks, they tried to burn the place down, but due to the fact of its concrete structure, they didn't do a real good job at that. The corpse, identified as being Gordon Call's, was missing teeth, hands, and feet, had a bullet hole in the head without a bullet, and was extensively covered with tissue bruises and fractured bones. It was very shocking and disgusting, as some of the local people who saw the photographs of Gordon Call's charred remains, which were taken by the coroner, they reported a stark and terrified look on his charred face. He had died in extreme terror, screaming violently from the pain. And the feds had gotten their man.
Some of these infiltrators are undoubtedly honest people that have run afoul of a maritime penal regulation and have caved in to the pressure put on them by lawyers and their minions to inform on others in order to avoid incarceration. Some do it purely for money. Others are agents of the lawyers who travel the Patriot Circuit, holding seminars and disseminating false information and surefire remedies guaranteed to be the proverbial magic bullets. Many good people have lost their property and liberty pursuing these false remedies sold by patriots for profit who are paid by the attorneys to lie and then double dip into their victim's pocket by selling the false information. And then there are other patriots holding seminars who truly believe that they have the answer and end up in jail after an attempt to apply their own theory. It is understandable how one can fall victim to a false patriot for profit scheme. Your authors have been victims of some of these schemes. People that run afoul of the American system of injustice are so desperate for some relief that they become easy targets of opportunity. Live and learn. The age-old warning of caveat emptor should be applied to this instant article. Do your own research and check it out. Education, however it is obtained, is usually expensive. Hopefully, most folks learn by their mistakes. But the dawn is near, the sun is rising. The path traveled by those seeking the truth of the fraud has been a long and arduous journey. It passes through a jungle growing over the hollow remnants of many small businesses, the ruins of family farms, the shells of homes once occupied by close-knit families, and passes by dead bodies and graves marking the way. The path to truth has been filled with stumbling blocks, seemingly insurmountable, and many forks lead to false trails. Many who have started down the path have found the journey so difficult that they have turned back. Others, more determined and of a stronger character, have perished along the way. A great debt is owed to those who have blazed the trail before us and marked at least part of the way, marked false trails and removed some of the stumbling blocks. Without the knowledge that they have gained to be built upon, your authors would have never discovered what they have. This article is not the work of any one man. It is the accumulated work of many. It is the culmination of many pieces of a giant puzzle that have been assembled with divine intervention. The authors sincerely believe that the timing of this revelation of fraud is key to the timetable of the Creator. His plan for the destiny of mankind and the universe has existed from the beginning, and the plan is nearing the final stages of execution. The lawyers are soon to suffer the woes described in the Gospel of Matthew chapter 23. The secular judges are soon to be judged by the judge of the universe. How can they defend themselves? You may be assured that most of all, they live in fear of their own judgment before the supreme judge. They are responsible for their own actions as observed by one jurist in the case of Robin versus Hardaway, 1 Jefferson 109, 1 Am. Juris 2D 14. A legislature must not obstruct our obedience to him, from whose punishments they cannot protect us.
That's all you deal in is debt. You don't deal in, there is no money.
Mr. Ingres, if you'd come up, sir, and stand beside Attorney David Al.
John Ingres is in the court. That's you. Before we go any further, I need to know who you are.
I am Judge Crocker, right here.
Thank you, clerk. Are you the CQV trustee who has appointed this judge as administrator and trustee of the constructive trust case number 458-2010-CR-01203?
Mr. Attorney David Al, your motion for competency evaluation is granted.
And I'm appalled at what I see happening in this country today. We are told that America is the land of laws, a nation built on laws. In point of fact, nothing could be further from the truth. America is run by people who are lawless. We have no law in America, and understand that. The law is whatever the powers that be in power happen to say it is today. Whatever they say it is, that's what the law is today. And it may change tomorrow.
Of the people or the corporate United States?
It's in favor of the banks. It's certainly not in favor of the people. What happens when you have a child is your child is given a Social Security number. They estimate how many taxes your child is going to pay over his or her lifetime. And they take that birth certificate and they issue it on the capital markets and they earn money on it.
Let me tell you why you're here. You're here because you know something. What you know you can't explain, but you feel it. You felt it your entire life, that there's something wrong with the world. You don't know what it is, but it's there, like a splinter in your mind, driving you mad. It is this feeling that has brought you to me. Do you know what I'm talking about? Matrix. Do you want to know what it is? The Matrix is everywhere. It is all around us. Even now, in this very room. You can see it when you look out your window or when you turn on your television. You can feel it when you go to work, when you go to church. when you pay your taxes. It is the world that has been pulled over your eyes to blind you from the truth. What truth? That you are a slave.
I'm here by special appearance only under a full representation. Sure. You're here on charge of careless driving. You're also here improper passing. You're also here for tinted windows, no insurance, no seatbelt. How do you plead to those charges, sir? I'm here by special appearance to challenge the jurisdiction, and furthermore, I don't understand the nature and cause of these proceedings, so I would like to ask a couple questions so I can properly be able to handle this matter. So, I'll enter the pleas of not guilty. I didn't enter that voluntarily. I don't understand the charges, sir. Do I have the right to understand the nature and cause of these proceedings? Sir. I don't yet understand the nature and cause of these proceedings. Do I have that right, sir? If you don't be quiet, I'm going to lock you up.
The Sixth Amendment. The key to the fraud hinges on understanding the Sixth Article of the Amendment of the Constitution of the United States. The discussion begins with the text as follows. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The key words is the emphasized portions are all and shall. All implies that there is more than one criminal jurisdiction. Shall makes the enjoyment of the right to be informed mandatory. The information or indictment must state the nature and cause in plain language that is understood by the accused. Many victims accused of offenses against the state or United States have found themselves in prison and all their assets forfeited for lack of understanding of the nature and cause of the accusation. In the classic document, Common Law Abatement by Don Quixote in the School of Law, Juris Doctorate, he shed some light on how the nature of the action was hidden from the public. The state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. They cannot create a new nature of action out of thin air. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, a separate court was established, and the action was in the nature of administrative. Live people could not be brought into administrative courts, as the only matter at issue was a breach of corporate charter by an artificial person. Somewhere along the line, the announcement in the complaint of the nature of the action was lost. The attorneys all got together and decided that it would be much simpler for them if there were only one form of action. So today, there's no disclosure of the nature of the action, unless one demands to know the nature and cause of the accusation by using a demand for a bill of particulars.
And today's legal term is bill of particulars. This is factual details submitted by a party upon request that further explains or clarifies the charges or allegations in a case.
Within the past couple of decades, they moved it to discovery, which is after arraignment, so the ability of one to challenge the jurisdiction and venue of the court was lost. This is because entering a plea accepts the jurisdiction. In this way, only subject matter jurisdiction was challengeable. If they say this is a matter at law, my defense against this jurisdiction is whether there is a live damaged party. I do not ask if this is an equity jurisdiction, because equity is not a criminal type of action. If they say this is a matter in hustings, which is the true nature of action of all administrative law, my defense against this jurisdiction is that I'm not an artificial person, unless I am a federal citizen, but that is quite another matter entirely. Unless they can show from the records in the Secretary of State's office that I have charted as such. If they say that this is an admiralty matter, my defense against this jurisdiction is whether the offense was committed on federal territory over which the state has retained concurrent jurisdiction, although I've still not found how the state exercises an admiralty jurisdiction in light of 28 United States Code subsection 1333. If they say this is a military matter, my defense against this jurisdiction is that, number one, I'm not a member of their military. I am, however, a member of the militia of the several states, but they do not operate as such anymore. And number two, the nation is not under martial law. Or is it? Given the fact that there are currently 14 notices from the presidents of a declaration of national emergency published in the Federal Register, we may very well be in a state of martial law. The one from March 6, 1933 is still in effect today. However, they're not going to admit the nature of the action, as this will admit their want of jurisdiction on the record for all to see. So they move to dismiss the charges every time. While I will never succeed in bringing down the current regime in this manner, at least other folks see what I'm doing, and some decide along the way that they want to learn this procedure. I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, that we could most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. As far as the compelling government interest doctrine, this is clearly matter founded in law, martial rule. The military authority is in the process of returning control to the civil authorities, but has not yet completed the process. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I am therefore unable to enter a plea to the charge until I have had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. The courts operate on silent judicial notice of presumption all the time. It is time for this to end. The Supreme Court has held there are no common law offenses against the United States, only those acts which Congress has forbidden, with penalties for disobedience of its command, are crimes. Actions to recover penalties imposed by act of Congress generally, but not invariably, have been held not to be criminal prosecutions. Oceanic Navigation Company versus Stranham. Hepner versus United States versus Regan. Contempt proceedings, which are at one time not considered to be criminal prosecutions, are no longer within that category. Compare In re Debs, 158 U.S. 564, 1895, with Bloom versus Illinois. What is the nature of the accusation? If common law crimes against the United States do not exist, what kinds of crimes do exist against the United States? Article 3, Section 2 provides for 4 different jurisdictions: law, equity, admiralty, and maritime. By process of elimination, we can automatically rule out law by virtue of the above Supreme Court holdings. Equity is defined as justice administered according to fairness as contrasted with the strictly formulated rules of common law. The term equity denotes the spirit and habit of fairness, justice, and right dealing with which regulate the intercourse of men with men. See Black's Law 6th edition. Equity deals with fictions like corporations. Since it is common knowledge that law and equity have been combined and are virtually indistinguishable from each other, and that anyone who has witnessed criminal proceedings in the courts easily recognizes that these criminal or quasi-criminal accusations are most usually contrary to the spirit and habit of fairness and justice and right dealing of men with men. Therefore, the cause of action cannot be inequity. Admiralty is defined in Bouvier's 1856 edition as the name of a jurisdiction which takes cognizance of suits or actions which arise in consequence of acts done upon or relating to the sea, or, in other words, of all transactions and proceedings relative to commerce and navigation and to damages or injuries upon the sea. Black, 6th edition, observes that the terms admiralty and maritime are virtually synonymous. Bouvier's 1856 edition defines maritime cause as 1. Maritime causes are those arising from maritime contracts, whether made at sea or on land. That is, such as relate to the commerce, business, or navigation of the sea, as charter parties, affreightments, marine loans, apothecations, contracts for maritime service and building, repairing, supplying, and navigating ships, contracts and quasi-contracts respecting averages, contributions, and jettisons, contracts relating to maritime insurance, and those between owners of ships. 2. There are maritime causes also for torts and injuries committed at sea. 3. In general, the courts of admiralty have a concurrent jurisdiction with courts of law of all maritime causes, and in some cases they have exclusive jurisdiction. As long ago as 1851, the Supreme Court recognized that the Congress has the power to extend the jurisdiction of admiralty and maritime causes to the land under the Commerce Clause and deprive the people of the right of a trial by jury. The following holding by the High Court pretty much says it all. This power of admiralty jurisdiction is as extensive upon land as upon water. The Constitution makes no distinction in that respect. And if the admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, with the same propriety and upon the same construction, be extended to contracts and torts on land when the commerce is between different states. And it may embrace also the vehicles and persons engaged in carrying it on. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state to another, and over the persons engaged in conducting them, and deny to the parties the trial by jury. Now the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. The very next year in 1852, the Supreme Court warned that this admiralty or maritime threat to liberty was encroaching on the land and morphing itself in an air-breathing creature, just as a harmless tadpole transforms itself into a frog. And this is a really ugly frog. If you had never seen a tadpole gradually go through this miraculous process, you might never believe that such a transformation could occur, changing a harmless water-breathing creature into an air-breathing predator. Next to revenue, taxes itself, the late extension of the jurisdiction of the admiralty are a great grievance. The American courts of admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought in England a dangerous innovation if the trial of any matter on land was given to the admiralty. Jackson versus Magnolia. Has the Congress expanded this admiralty and maritime jurisdiction? The answer is a definite and emphatic yes. One only need to examine the codification of Title 18 in the United States Code, Section 7. The broad language of Title 27, Code of Federal Regulations, Part 72.11, makes almost all crimes, whether or not they are federal or state crimes, commercial crimes. In the Propeller Genesee Chief Supra, it was revealed that admiralty courts have jurisdiction over interstate commerce. So it would follow the crimes listed in 27 CFR 72.11 are cognizable in an admiralty or maritime court, and such are commercial courts. The relevant part of the text is as follows. Commercial crimes. Any of the following types of crimes, federal or state, offenses against the revenue laws, burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale or possession of deadly weapons, prostitution, including soliciting, procuring, pandering, white slaving, keeping house of ill fame and like offense, extortion, swindling and confidence games, and attempting to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if such were commercial crime. In the Ebsworth and Ebsworth Lecture of 1994 Infra, Proctor Winswall states, Congress has been repeatedly held by the court to have the power to extend the admiralty and maritime jurisdiction by statute, and Congress has repeatedly exercised that power. What many of the victims accused of maritime crimes don't realize is that admiralty and maritime jurisdictions were merged with the law and equity jurisdictions in 1966. See Federal Rules of Civil Procedure, notes to supplementary rules for certain admiralty and maritime claims. All four causes of action, or natures of the cause, which were once separate and distinct, are now rolled into one set of rules and indistinguishable from one another in our modern courts. Federal Rules of Civil Procedure, FRCP Rule 1, provides that the rules govern the procedure in the United States District Courts in all suits of a civil nature, whether cognizable as cases at law or in equity or in admiralty, with the exception stated in Rule 81. Rule 2 provides that there should be one form of action to be known as civil action. Federal Rules of Civil Procedure Rule 9H provides in part, if the claim is cognizable only in admiralty, it is an admiralty or maritime claim for those purposes, whether so identified or not. Federal Rules of Civil Procedure Rule 38E provides that these rules should not be construed to create a right to a trial by jury of the issues in an admiralty or maritime claim within the meaning of Rule 9H. Well now, aren't the rules revealing? Maybe this explains why the judge can amend or reverse a jury verdict or even jail the jurors for contempt if they don't do what the judge tells them to do. It has happened. The jury is just there for window dressing to make the sheep think that there is a trial by jury. Law, equity, admiralty, and maritime, the once separate and distinct jurisdictions, are now neatly rolled into one set of rules, tried in the same courtroom with the same judge on the same docket and with nothing to distinguish the different jurisdictions from one another. If the criminal accusations that plague Americans today are not in the jurisdiction of common law or equity, they must be in admiralty or maritime jurisdictions. And though admiralty and maritime jurisdictions are virtually indistinguishable, Bouvier's definition of a maritime cause as those arising from maritime contracts, whether made at sea or on land, fits the bill. For the sake of illustration, let's take time to consider the condition of military personnel. When a young man enlists in the armed forces, he signs an enlistment contract that binds him to the law of the Code of Military Justice. This Code of Military Justice cannot apply to civilian folks who are not contracted. Under the Code of Military Justice, the accused is guilty until proven innocent. If the accused wishes to defend himself, he is put into the position of trying to prove a negative, a virtual impossibility. In other words, he is put into the position of proving that he did not do something. The military court or court-martial, where these military cases are tried, is a legislative criminal court established under the legislative power of the Congress to regulate the armed forces. Their jurisdiction is entirely penal. An action upon a penal statute is defined as an action for the recovery of a penalty given by statute. In a broad sense, the term has been made to include all actions in which there may be a recovery of exemplary or vindictive damages, an action in which the judgment against the defendant is in the nature of a fine or is intended as a punishment, and disciplinary. The word penal is inherently a much broader term than criminal, since it pertains to any punishment or penalty and relates to acts which are not necessarily delineated as criminal. Military personnel are subject to court-martial penalties because they are under a maritime contract. Did you ever notice that Texas has a code of criminal procedure, but not one criminal law? That's right, there is no criminal code and not one criminal law in Texas, but there is a penal code that is just chock full of offenses and more being added every time the legislature convenes. And if you have done battle in the Texas court system, you'll have noticed that the courts don't follow the code of criminal procedure very well. If you make enough noise, they will give it a little bit of lip service, but the judges mostly ignore it. The courts have held, power of punishment is vested in the legislature, not in the judicial department. It is the legislature, not the court, which is to define a crime and ordain its punishment. U.S. versus McLean. The legislature may declare that the doing of certain acts shall constitute the offense of sodomy and may ignore, if it sees fit, the common law elements of the offense. Slusser versus State. Under Texas law, no act or omission is a crime unless made so by statute. Dawson versus Vance. Black's Law 6th edition defines a penal action as a civil action in which a wrongdoer is subject to a fine or penalty payable to the aggrieved party. The word penal is inherently a much broader term than criminal since it pertains to any punishment or penalty and relates to acts which are not necessarily delineated as criminal. Action is essentially penal if amount sought to be recovered is arbitrarily exacted for some act or omission of the defendant. The legislature may create an offense and in same enactment provide exceptions to its application. Williams versus State. In summary, and according to the courts, the legislature defines crimes, can create a crime while ignoring the common law elements of a crime and mandate the punishment for the crime it creates. There is no crime unless it is created by the legislature. All of this certainly flies in the face of the common law rule that there must be an injured party for a crime to exist. These creations of the legislature are most certainly maritime crimes. In Howard Freeman's The UCC Connection, he explains why the courts are hiding the admiralty jurisdiction from the general public. He states that the reason they cannot call it admiralty jurisdiction is that your defense would be quite different in admiralty jurisdiction from your defense under the common law. In admiralty, there is no court which has jurisdiction unless there is a valid international contract in dispute. If you know it is admiralty jurisdiction, and you have admitted on the record that you're an admiralty court, you can demand that the international maritime contract to which you are supposedly a party and which you supposedly had breached be placed into evidence. No court has admiralty maritime jurisdiction unless there is a valid international maritime contract that has been breached. So you say, just innocently like a lamb, well, I didn't know that I got involved with an international maritime contract. So, in good faith, I deny that such a contract exists. If this court is taking jurisdiction in admiralty, then pursuant to Section 3-501 of your UCC, under presentment, the prosecutor will have no difficulty placing the alleged contract into evidence so that I may examine and possibly challenge the validity of the contract. What they would have to do is place the national debt in the evidence. They would have to admit that the international bankers own the whole nation and that we are their slaves.
You'll handle us. You know your predecessors had much more respect. Okay, you have some skill.